Hi, everyone. Welcome back from your Labor Day break. I know that it's been mentioned in class, but I'll go ahead and repeat it, that there is a recording on incorporation and freedom of religion that won't be covered in class, so it's something that you'll need to watch on your own, but will help you prepare for the exams and get you provide you with more knowledge about Chapter 4. So here we're going to move on to freedom of speech and press. All right, freedom of speech and press. I think the primary question to ask would be, are there any limits to speech and press? And as you read through Chapter 4, that's an issue that I would imagine you'll come back to and think about. Are there times in which there needs to be a limit to how a person expresses oneself on speech and press? This is through a series of court cases that has established some boundaries, or at least some history that the courts can rely upon when confronted with other cases on whether or not it's an appropriate use of speech or press in any particular situation. So, for example, one of the first cases this is brought out on the issue of could there possibly be limits to speech would be Schenck versus United States in 1919. This is mentioned on page 128 in your text. The words are used in such circumstances and are of such a nature as to create a clear and present danger. So that phrase, to me, always strikes me as being very obvious and at the same time also somewhat murky. How do you determine exactly what does it mean to be clear and present danger? So the example that was used, and this was brought out during a time of protest in World War I, that this was clear and present danger would be as if somebody would be falsely shouting fire in a crowded movie theater. So it's causing panic. There's no reason to cause the panic. It's made up. So today we could perhaps look at that in our modern society and consider someone saying they have a bomb on board a plane, and that's going to cause panic, would cause the flight to be diverted. All kinds of issues and preparations would have to change. And if it was made up, it's creating a clear and present danger. But is protesting a war a clear and present danger? Is asking people not to participate in a military draft creating clear and present danger? In 1919, it was determined that it was. So this also shows us that there are different interpretations of what it might mean to say that there's a clear and present danger. But this is the clear and present danger test. Take that into consideration as you read through this chapter. Then we can see the fighting words clause, page 129, speech that directly incites damaging conduct. So as a result, notice that word directly. So this is a case then where the speech is that an expectation is if there is no other response than some sort of damaging conduct, a fight, and that's the expectation of what that speech would do. Now, in most instances, though, could someone claim that they had this immediate reaction as a result of the words that they heard, the fighting words? But in some ways, that's compared to someone going to a baseball game, knowing what can happen at a baseball game, and they get hit by a foul ball. Would they have standing to sue the baseball team? can't really see a situation unless there was very little preparation on the part of the baseball team to prevent people from getting foul balls, getting hit by foul balls. But there's an expectation that certainly in parts of the stadium, you could expect to at least potentially get hit by a foul ball. So that becomes a way of saying if you went to a concert and there was foul language at the concert, but did you not know that that could happen before you went there? You went to a political rally and you were offended by some of the statements made by some of the candidates at the rally. Did you not expect that maybe some of those statements could be made? So very seldom, as your textbook mentions, can fighting words be used as a good defense for a violent reaction. We do see that where we are right now as a society through the use of the courts and how the courts have reacted to speech, that speech is paramount. It pretty much is the case. The idea of limiting speech very seldom happens. So the courts have protected flag burning, symbolic speech. And so it may be offensive, but is the freedom of speech meant to protect speech that might be offensive? So that's brought out on page 132. You also, of course, have the infamous case of the group led by Reverend Phelps, who protest soldiers' funerals. And there's certainly been many people who have been upset with the Westboro Church for doing that. It's quite offensive. But again, the courts have protected this offensive speech. And so you can read about that on pages 132 and 133. So what we have seen in the last 30 or so years for sure has been a very consistent support by the Supreme Court for freedom of speech. This also applies to freedom of the press. The courts have been supportive of the press by reporting activities that the government would prefer that they not report, that they not publish. So prior restraint is where the government, the attempt by the government is to prevent the publication of a newspaper. And consistently, the press, the Supreme Court has, and other courts have said government cannot prevent this publication of cannot prevent the publication of a newspaper. And there's an exception, of course, and that is if there are extraordinary circumstances, brought out on page 133. So the standing of prior restraint, the establishment of that, was brought out in Neer versus Minnesota, that there's very few circumstances in which prior restraint is found to be constitutional. And New York Times versus United States, the government could not block the publication of what was referred to as the Pentagon Papers. So again, these are papers that are pretty damning against some government officials and just the overall strategy of the United States government in the Vietnam War. And the government overall, collectively known as the government, individuals within the government didn't really want those that material to be publicized and the public could read about it. Well, the courts ruled in favor of the New York Times. And does the public have a right to know, even if it may make the government look bad? And perhaps, especially if it makes the government look bad, is that a reason then to support freedom of the press? But let's spend some time here. I'm really wanting to see some good comments here. This is something you ought to be thinking over. So notice in the slide before that prior restraint is almost never allowed, but it could be allowed if there are extraordinary circumstances. So here's our question. What might be an extraordinary circumstance that would allow the government to block publication? think that over, share that on chat. We'll pause and you can write out your answers. Okay, we can also see then that there are situations in which individuals in groups could be successfully sued for libel or slander, that they're causing personal harm. And of course, this personal harm could go beyond just hurt feelings. I mean, this could be a situation where someone is a doctor, a dentist, psychiatrist, a minister, a instructor, a teacher, professor, that if statements written or verbalized could cause personal harm, it could also mean that that individual in which those statements are directed against could actually lose that person's livelihood. And so it becomes an economic harm. And so that's where lawsuits could certainly come in. So as you can see here, and this is from page 134, libel is a written statement that is malicious, scandalous, and defamatory. And slander is a spoken statement that is malicious, scandalous, and defamatory. I do believe it's important to note here that the press can make a mistake. So they could say about an individual something that's not correct. But what if the mistake was malicious? In other words, there was really no reason to make such a statement about an individual, and it did cause harm. And that's where you could see a successful lawsuit against an individual or a publication based on what's been said or written. So there is some standing here to say that words can be hurtful and that words can cause damage, and they could be grounds for a lawsuit. So we also have, for freedom of the press, there could be a limit based on obscenity and the production of work that is perhaps questionable on what might be the majority's moral standards. But an obscene piece of literature, art, however it may be described, can actually fall within, can fall outside the boundaries of the law. And someone could then be prosecuted for publishing obscene works. And this is described on pages 135, 136. The standards for that are referred to as Miller versus California, or the Miller test, which comes from Miller versus California. And you'll see on pages 135, 136, these standards. So if there was a court case charging that an individual was producing obscene work, to determine if the work was in fact obscene, it would have to fit these standards. It would have to go against these standards, or in some ways be described by these standards. And that would be up to a jury to make that determination. But again, we're reminded as we look over freedom of the press and freedom of speech that the courts have been pretty consistent. This is from 2011 in protecting the First Amendment as they see it. So in other words, they give a broad leeway to the First Amendment, freedom of speech and freedom of the press. And you'll see in my previous recording, they also do that for freedom of religion. So in this case here, Brown versus Entertainment Merchants Association, the Supreme Court struck down a California law banning the sale of violent video games to children, saying that the law violated the First Amendment. That's up to parents to decide whether or not a child should have access to a violent video game, not up to the government. So we can see that freedom of speech, freedom of the press has been consistently protected by the Supreme Court. And in other words, the protection has a broad scope and allows for considerable amount of expression. All right, we'll stop there with freedom of speech. So again, if you look at these two recordings, one that we've had in class, the other one that is available to you, we've covered here religion, speech, and press. And the last of our recordings on Chapter 4 will cover the rights of criminal protection, people who have been, the rights of the criminally accused, which will involve the 4th, 5th, 6th, and 8th Amendments.